The Scripps News Washington correspondent Stephanie Liebergen joins us live from Capitol Hill this morning. A lot going on right now, Stephanie, with the Supreme Court. We are awaiting perhaps a number of really high-profile rulings coming down really any minute now, maybe even while you're talking. Can you talk to us about some of the big decisions that we might be expecting?
Well, Patrick, one of the big decisions we were waiting for is the first case handed down from the Supreme Court this morning. This is a case about mail-in voting, and it popped up online just as you were starting to toss to me, so I haven't had a chance to look at it yet. But it says the federal election day statutes do not prevent Mississippi from counting absentee ballots postmarked by election day, but received up to 5 days thereafter. Nothing in federal election day statute requires ballots to be received by election day. So, just based on that quick sentence that I read, it does appear that the Supreme Court is letting stand state laws that allow mail-in ballots that are postmarked by election days to arrive later. Mississippi, for example, the case that this stemmed out of, allows mail-in ballots to be received up to 5 business days later. Other states like California, that is now an all mail-in ballot state, I believe mail-in ballots can arrive 10 or even 14 days after election day.
Donald Trump and the Republican National Committee just suffered a major defeat at the Supreme Court. And the most damaging part is not only that they lost, it is who made them lose. Republicans went to the Supreme Court trying to throw out mail-in ballots that were legally cast, legally mailed, and postmarked by Election Day. These were not fake or illegal votes. These were ballots from real voters who followed the rules. But because those ballots arrived after Election Day, Republicans argued they should be rejected.
This is something that we have heard President Trump complain about a lot, saying that ballot counting, vote counting, everything needs to be done by Election Day. But this decision from the Supreme Court appears to kind of push back against that rhetoric. Nothing about Election Day vote tallies is permanent. Everything we get on Election Day is just the temporary, the preliminary results. Always results are certified later, and this decision is a really big one. There are at least 15 states, Patrick, that allow mail-in ballots to be counted if they're postmarked by Election Day, but they are received later. And so this is for election advocates. This is likely going to be a very big win for them. But this is just the first case that we are getting from the Supreme Court. And there are others we are keeping our eyes out for. There were 8 cases pending before we got into today, and 7 of those 8 are major cases. So this is just one of the 7 major cases we were waiting for, but this really is a big one, Patrick.
Think about what that means. A voter fills out a ballot. A voter signs it, mails it, and gets it postmarked on time. But because the mail takes a few extra days to arrive, Trump's side wanted that vote thrown away. Not counted, not protected, not respected. Thrown out. And the Supreme Court, of course, said no.
This is not a win for Republicans who were challenging this. Mississippi has a state law which allows ballots to be counted, mail-in ballots after Election Day. If they come in, they're postmarked and meet the state requirements, but is a 5-4 loss for Republicans. And an interesting cobbling together of who wrote on this. Justice Barrett wrote the opinion. Justice Roberts joined her along with Justices Sotomayor, Kagan, and Jackson. So those 5 stuck together on this. The dissent comes from Justice Alito. Thomas Gorsuch and Kavanaugh join him. And essentially what the majority said is that these federal statutes setting Election Day don't prescribe, or they don't stand in conflict with states that want to say, okay, we have a procedure to count ballots after Election Day. Justice Alito, writing for the dissent, says today's decision is inconsistent with the terms of the Election Day statutes, contemporary election law principles, 2 centuries of historical practice, and the case law on the question presented. So if you're a state out there that counts ballots after Election Day based on your state law, that state law will stand. We wait on more opinions now, guys. More to come.
Even more importantly, the opinion against the Republican National Committee was written by Amy Coney Barrett, one of Donald Trump's own Supreme Court appointees. That is what makes this ruling so explosive. This was not a liberal court attacking Trump. This was not a Democratic judge stepping in. This was one of Trump's own justices rejecting the argument from Trump's political movement.
And again, Stephanie, so from SCOTUS blog, our understanding is that, as you've been saying, this Mississippi law that allows mail-in ballots to be counted days later, the idea here is that these states still say you have to postmark that ballot by election day. So if that's Tuesday, someday in November, it's got to be, you got to vote on that day, and it's got to be put in the mail. But if it is received days later, that would still be valid. That's what this court is saying.
Exactly. And the challenge in this case was those challenging the Mississippi law, trying to argue that the federal election laws require ballots to be received by election day. And that is what the Supreme Court is disagreeing with, siding with the state of Mississippi and the at least 14 other states that allow mail-in ballots to be received later. Again, across the board in all of these states that allow mail-in ballots to come in a little bit later, they need to be postmarked by election day. But think about when you put anything in the mail, you or I, maybe I've gotten comments from my mom where maybe she put something in the mail to me. Sometimes it gets to me from Kansas City to here in DC within 2 days. Other times it's taken 2 weeks for a letter to get to me in the mail. And that kind of inconsistency and something maybe getting lost in the mail, that happens to all of us, and that can happen to someone's mail-in ballot. And that is in large part why the states have these regulations allowing ballots. Again, they have been postmarked by election day. That means the ballot was filled out and completed by election day. And then it just gives a little extra time for the USPS, for mailmen to get the ballot to the election officials so it can be opened and counted properly. So
the case came out of Mississippi, one of the reddest states in the country. Mississippi has a voting mail rule that allows ballots to be counted if they are postmarked by election day and arrive within 5 business days. That rule exists for one obvious reason. Mail is not instant. If someone walks in a polling place on election day and casts a ballot, that person votes on time. If another person puts a ballot in the mail on election day, and that ballot is properly postmarked, that person also votes on time. The only difference is how the ballot travels. But the Republican National Committee wanted to turn that difference into a weapon. They argued that election day means the ballot must be physically received by election day. Under that rule, a voter could do everything right and still lose their vote because the postal service moved too slowly. That is the danger the Supreme Court rejected.
Passed is what our
Mr.
law.
Stewart, I just want to ask a clarifying point to this. Is it possible for a portion of Mississippi's statute to be unlawful? Not just go with me here. A portion of Mississippi's statute to be unlawful insofar as it potentially permits recall, but still that, would not address whether Mississippi's statute was unlawful insofar as it allowed ballot receipt after Election Day?
Yes, Your Honor. I mean, I think one possibility would be like, hey, look, you need a more unambiguous finality here, and you need to foreclose recall period, full stop.
Okay. And on this question, I just want to make sure I understand what you're saying. When you said, yes, my friends on the other side say it's okay for private parties to deliver just like you do, are you saying that that's just a manner of receipt? And whether the ballot is received before or after the election, on all sides, everybody agrees that absentee ballots can be turned in by having, the neighbor, the party operative, or whatever, scoop them up and bring them to the ballot box?
Your Honor, I mean, maybe, I'm not sure if I answered the earlier thing as crisply as I could. I'm not comfortable with the neighbor piece. I do have serious concerns about that.
But is that tied to the ballot receipt problem, or is that just tied to, hey, maybe this is an unlawful way of executing absentee balloting, regardless of when the ballots make it to the official?
I think it's the finality of the choice that has to be done by Election Day. And
Okay.
my concern is that if you're not sending it by mail or common carrier,
Amy Coney Barrett's reasoning was simple. Federal law sets the day when voters must make their choice. It does not automatically decide the exact day every ballot must physically arrive at the counting office. That distinction matters because if the voter make the choice by election day and the state has a legal rule giving the ballot time to arrive, then that vote should not be erased. These rulings does not only protect Mississippi's system. According to the discussion in the transcript, it also protects similar mail-in ballot rules in 14 states and Washington, D.C. It also matters for military and overseas voters because ballots coming from military bases or foreign countries often need extra time to arrive. So this is not just about one red state. This is about whether legal voters can trust that their votes will count.
The Supreme Court has just issued a critical ruling ahead of the midterm elections. The justices are weighing in on whether states can count late arriving mail-in ballots that were sent on time. The Supreme Court upheld state laws allowing the counting of late arriving mail-in ballots if they were postmarked by Election Day. Let's get straight to our senior Washington correspondent, Devin Dwyer, who covers the Supreme Court. Devin, this was a surprise.
It sure was, Kira. This was a 5-4 decision by the Supreme Court in an opinion written by Justice Amy Coney Barrett, the youngest conservative on the bench, upholding a Mississippi law that allows the late arriving ballots up to 5 days after Election Day to get counted in that state, and effectively preserves similar statutes in 29 states around the country that have a grace period for voters who don't get their ballots in by Election Day, but a short period after. This was a decision based largely on federal law, where Justice Barrett saying that federal law says nothing about late arriving ballots or the counting thereof. Therefore, states have the ability to set their own policies. And that means those policies now basically will stay in place both for the midterms and likely beyond, upending what many had hoped would be a change in policy, specifically Republicans who brought this challenge. Of course, President Trump very supportive of that as well.
Trump and the RNC were trying to create a rule that would make mail voting more uncertain. They wanted to make it easier to challenge ballots, easier to reject ballots, and easier to shrink the number of votes counted after Election Day. And that fits into a much larger political strategy. For years, Trump has attacked mail-in voting. He has tried to make people believe it is suspicious, dangerous, or connected to fraud. But the speakers in the transcript make one point very clear. There is no evidence of widespread voter fraud that justifies throwing out legal ballots like this. The real issue is not fraud. It is power. The more restrictions placed on voting, the harder it becomes for certain people to vote. Working people, elderly voters, disabled voters, students, military families, people who cannot stand in line for hours, people who cannot take time off work, people who depend on the mail to participate in democracy. That is why this ruling matters. The Supreme Court told Trump and the RNC that a lawful vote does not become unlawful just because it arrives a few days later under state law. And politically, this is a brutal blow.
Can we also now stop pretending that the elections are not secure?
We can stop when they become secure. That's when we can stop doing it.
Where's your evidence that they are not secure?
I think, first of all, the fact that we do not have to show ID is a disgrace. Number two, I will find you videos, including 2024 in Connecticut, when you have on a security camera one person dumping in mail-in ballots.
I'm not going to watch it. I'm not going to watch your YouTube video.
Of course you don't want to watch it because it goes against your agenda. But if you opened your eyes and saw something that goes against what you believe, you'll see that it's not secure.
But hold on, Emily. Don't tell me to open my eyes.
What about a better argument than, oh, it doesn't happen?
Hold on, Emily.
Which it happens,
Let me just let Emily finish her what she was claiming, because she said, you said that there was a video in Connecticut. What's the point of the video?
My point is that mail-in ballots are not secure because they are mishandled.
Don't try to get off of it now.
Hold on. What's the point of the video in Connecticut that you're talking about? What happened in Connecticut?
One person dumped multiple mail-in ballots.
And then what happened? You said it was on video. So was that person charged?
I don't know.
You don't know? You're telling me that there's massive fraud and it's caught on video, and you can't tell me whether it was real or not,
We can look into
whether
it.
the person was charged or not.
I really hope he was charged. But how many
here's the
instances
thing.
were not caught on camera?
hold on.
I didn't have cameras.
Hold on, Emily.
Did I have
we
cameras
all the way
on my
down the
mail-in ballot?
conspiracy.
No.
I'm just saying that you're basically.
It is absolutely a
It is a letter. It can be
Listen,
mishandled.
I'm just
It's a
saying,
joke.
if you have video evidence.
How about
That answer is a
you
joke.
defend the fact that we don't have to show voter ID?
Hold on a
You
second.
defend that too?
First of all, that is a ridiculous thing. So, do you believe that actually? In 50 states, that nobody has to show any
I didn't
ID.
say nobody. Everyone should be required.
What are you saying? In which states can you vote and no one knows who you are? You have to show no where you live, nothing. So which states are those?
How many New Yorkers said?
I didn't know the answer because you didn't know it.
How
I
many?
know
Should I give you a
because
list
you
of
didn't know
names?
it.
Let me post on Instagram.
Here's
Everyone
the
who
thing.
didn't show ID in the New York election, come forward. People will come forward.
Here's the thing.
It's a joke.
Here's the
You're a
thing.
joke
But
because you didn't answer that question. You tried to go around the corner.
Okay, hold on.
You tried to go around the
Go
corner.
ahead, Ashley.
Even more so if everyone's already doing it.
Hold on, Emily. Hold on, Emily.
Trump can attack Democrats, he can attack election officials, he can attack the media, but when one of his own Supreme Court justices writes the opinion against his side, it becomes much harder to spin. This decision sends a clear message before the election. If a voter follows the law, mails the ballot on time, and the state says that ballot can arrive within a legal window, that vote deserves to be counted. Not only when it helps Republicans, not only when it helps Democrats, but because democracy depends on legal votes being counted, not thrown away for political convenience. Trump and the RNC tried to convince the Supreme Court to make it easier to discard lawful ballots. Instead, they walk away defeated. And the justice who delivered that defeat was appointed by Trump himself.